Hello and welcome to episode 11 of my Employment Law Snapshot. In this episode I'll be talking about Donald Trump, taxis and Toblerones. Now I'm filming this edition on Tuesday the 8th of November and the polling stations have just opened for the American presidential elections. So at the moment I've no idea who's won, even though this broadcast will be uploaded when the result is known. Therefore I'm going to cover both bases. And so Hillary Clinton has won, just as all the polls pretty much predicted since the beginning of the presidential race. Phew, that was a close call, but common sense has prevailed. Okay everyone, Donald Trump has just won the presidential election, and America has already been renamed the United States of Trump. I'm not remotely concerned about this, everything will be fine. I'm just going to pack up a few essential supplies of food and water and head down to the bunker at Tibble Towers. On a similar note, this week's case is also about a recent outcome arising from two warring factions that have been in dispute for the last 12 months. I am, of course, talking about the Uber case. On with the law. This week's case is called Aslam and Others against Uber and Others. A number of Uber drivers brought claims for unlawful deductions of wages through an alleged failure to pay the national minimum wage and for a failure to provide paid holiday leave. Two of the drivers were selected as test claimants. Now, in order to be successful with their claims, the drivers had to demonstrate that they were workers, as opposed to self-employed drivers. In order to be classed as a worker, the Employment Tribunal had to consider a three-stage test. Firstly, there had to be a contract between the driver and Uber. Secondly, the driver had to perform services personally for Uber. And finally, the Employment Tribunal had to consider whether the drivers had their own business undertaking, and if so, whether Uber should be viewed as a client or customer of the driver's business. The Uber case essentially hinged on the third part of the test, which meant that the Employment Tribunal had to look at the reality of the working relationship between Uber and the drivers, and in particular the level of control that Uber had over the drivers themselves. Uber argued that they were not providing a transport service. Instead, it said that it was just a technology company, which was essentially an app putting drivers and passengers in touch with each other. Uber said that the drivers were free to choose which fares to accept and didn't have to work at particular times. It said that the drivers were required to maintain their own vehicles and pay for the running costs. Finally, Uber said that the drivers didn't have to work exclusively for them. The drivers argued that Uber controlled how much passengers were charged and that Uber required the drivers to follow particular routes. They said that the passengers paid Uber for the journey and then Uber paid a percentage of the fare to the drivers. Finally, the drivers said that Uber used a rating system to rate their performance. As such, the drivers argued that Uber had sufficient control over the drivers to warrant a worker relationship as opposed to a self-employed one. There was also a lot of scrutiny by the Employment Tribunal of the contracts that existed between Uber and the drivers and Uber and the passengers. Uber argued that the agreement with the drivers was clear and that it was designed to allow both parties a sufficiently flexible relationship so that the drivers were genuinely self-employed. The drivers argued that the agreement didn't properly reflect the reality of the relationship between them and Uber. It's probably fair to say that the Employment Tribunal was pretty scathing about the submissions put forward by Uber, particularly the one in which it said that it was not running a transport service. The tribunal concluded that Uber's central function was to carry people in cars from one point to another, and that it operated in part through a company that's regulated as a private hire vehicle operator. The Employment Tribunal also relied on the fact that in submissions to the Greater London Authority Transport Scrutiny Committee, Uber had boasted about providing job opportunities and potentially generating tens of thousands of jobs in the UK. The tribunal also agreed with the findings of the North Carolina District Court in a similar case brought by Uber drivers in America that Uber does not simply sell software, it sells drivers. The tribunal also said that Uber's view that the drivers were simply a collection of 30,000 small businesses linked by a common platform was faintly ridiculous. As far as the actual relationship between Uber and its drivers was concerned, the tribunal concluded that Uber exercised a high degree of control over the drivers. Some of the examples that the tribunal referred to in order to demonstrate this point included the fact that Uber fixes the fare and drivers can't agree a higher sum with the passenger. Uber requires drivers to accept and or not cancel trips and enforces this requirement by logging off drivers who breach it. Uber sets the default route for each trip and the drivers might face deductions from the fare if they depart from it. Uber subjects drivers through its rating system to what the tribunal said was effectively a performance management or disciplinary procedure. And Uber handles passenger complaints and determines issues about passenger rebates, sometimes without involving the driver affected. In conclusion, the tribunal decided that the two test claimants were, in fact, workers. As such, they're entitled to 5.6 weeks paid annual leave, a maximum 48-hour average working week, and the national minimum wage. There's been a lot of discussion about how this decision could impact on the so-called gig economy. But let's not forget that Uber are likely to appeal the decision. It's only the decision of an employment tribunal and therefore it's not binding on future cases. And importantly, the decision is highly fact sensitive. Even the tribunal itself suggested that Uber could have come up with a business model that would have led to a different decision. So, as far as the gig economy is concerned, this isn't the end of the road yet for the self-employed, but it certainly means that operators in the gig economy need to be very careful to stay on the right side of the law. And finally, staying on the subject of the presidential elections, before I videoed this broadcast, I happened to look on the BBC News website to get an update on what was actually happening. Now, bizarrely, on the most read section of the BBC News page, the presidential election languished in second place. In first place was the far more controversial issue about the fact that the manufacturer of Toblerone has decided to reduce the weight of the chocolate bar and make the gaps between the triangles bigger. It's nice to know that us Brits have got our priorities absolutely right. Until next time. Thanks for watching. I hope you enjoyed our episode. If you want to subscribe to our YouTube channel for more updates, click here. If you want to follow us on our Twitter page, which gives you a daily heads up about everything employment law related, click here. Or if you just want any more information or help, please go to our website by clicking here. And of course, all of the links are below. Once again, thanks for watching and see you next time.